In medieval Europe, your marriage wasn't legally binding until a crowd of nobles watched you go to bed. And that wasn't a weird regional quirk, it was the entire point. Because without witnesses, your marriage could be erased like it never happened. We're talking about a legal mechanism that decided who inherited kingdoms, who got executed for treason, and whether your children were legitimate or bastards with no rights whatsoever. Dozens of dynasties rose or collapsed on the question of whether the right people were standing in the right bedroom on the right night. This wasn't embarrassing. This was survival. And the terrifying part is, it worked exactly as designed. Start with the basics. Medieval marriage law ran on two tracks, the church track and the property track. The church cared about consent. Did you both say yes? Fine, you're married. But the nobility cared about something much messier, proof. Because a marriage that could be quietly disputed later was a weapon. An annulment didn't just dissolve a union. It retroactively erased it. Your children became illegitimate. Your widow lost her dower rights. Your entire dynastic line could be unpersoned by a clever lawyer and a cooperative bishop. So the solution was witnesses. Specifically, witnesses in the bedchamber. The ritual had a name, the chivalry in France, or more formally, the bedding ceremony across most of Western Europe. After the feast, the wedding party would escort the couple upstairs, undress them. Yes, physically undress them, put them into bed together, and then stand there. Sometimes they'd pull the curtains. Sometimes they wouldn't. The point wasn't voyeurism. The point was that 15 earls could later swear under oath that yes, these two people were placed in a marriage bed together, in the same room, at the same time, with no impediment. That testimony was a legal shield. And for most of the medieval period, it was genuinely necessary, because the alternative was far worse. Take Margaret of Burgundy in 1315. Her marriage to Louis X of France had produced a daughter, but Louis needed a male heir. The bedding witnesses from their original ceremony were still alive, still talking. Without them, the annulment lawyers would have had a much easier time. With them, the whole process got complicated, expensive, and politically ugly. The witnesses weren't just guests. They were, functionally, insurance policies. If you're the kind of person who just learned that medieval earls had a legal obligation to watch the wedding night, and your first thought was, subscribe and like the video because that's exactly the energy this channel runs on. Drop a comment with the strangest historical legal mechanism you've ever heard of, and share this with whoever in your life would absolutely lose sleep over it. Because we haven't even gotten to the part where this whole system spectacularly backfired. Henry VIII. You knew he was coming. Henry's first marriage to Catherine of Aragon lasted 24 years before he decided he needed out. The theological argument was complicated. The legal argument was simpler. Had the marriage been consummated? Catherine had previously been married to Henry's older brother Arthur, who died 5 months into the marriage. If that marriage was consummated, Catherine and Henry's union was theologically void from the start. No witnesses required, just a dead prince and competing testimony. Arthur's bedding ceremony had witnesses, several of them. One, William Thomas, reportedly heard Arthur say the morning after that he'd been in the midst of Spain, a charming 16th century way of saying the deed was done. Catherine denied it her entire life. Henry's lawyers cited the witnesses. Catherine's lawyers cited her word. The entire English Reformation, the break with Rome, the dissolution of the monasteries, all of it traces a direct line back to a disputed bedchamber in 1501, and whether the witnesses were telling the truth. One wedding night, 30 years of consequences, and Henry didn't learn. His fourth marriage, to Anne of Cleves in 1540, lasted 6 months. His annulment argument? Non consummation. His evidence? His own testimony, and the notable absence of anyone willing to swear otherwise. And, wisely, agreed to everything and walked away with 3 houses and a generous pension. The system, for once, worked in someone's favor. Here's the thing nobody talks about. The bedding ceremony wasn't designed to humiliate anyone. It was designed to protect women. In a legal system where a husband could claim a marriage never happened, could walk away, take the property, leave the children without a name. Witness consummation was one of the only mechanisms a wife had to prove the union was real. The witnesses weren't there for the husband. He had the land either way. They were there because without them, a powerful man could erase a woman from the record entirely. The mechanism got used against women too. Henry used it against Catherine, against Anne, but the original architecture was defensive. It was built by people who understood that in a world where men controlled the courts, women needed something harder to fake than a signature. They needed 15 earls in the room. The bedding ceremony died out gradually after the Reformation, when Protestant theology shifted toward private consent over public ritual. But the underlying problem, how do you legally prove a private event happened, never went away. We still argue about it in courts today, just with different evidence and fewer earls. Subscribe and like if this broke your brain a little, and drop the most absurd legal loophole from history in the comments. Genuinely, I read them. Next video is about the medieval legal concept that let you sue a dead man's ghost for debt. That one's already up there.